Court's back in session. Honorable Glenn Coe presiding.
All right, good afternoon. Please be seated. I do apologize for the delay. Apparently, Mrs. Dippolito's been waiting downstairs, and we couldn't get her upstairs, so I do apologize that we're running about 20 minutes late. All right, we have defendant's motion for jury interviews and motion for new trial. Mr. Rosenfeld, it's your motion. So you go ahead and start. I guess my first question for you is, haven't I already ruled on this?
Yes, Your Honor, but with any motion for a new trial, it's based on issues that have been ruled on during trial and are readdressed in the motion for a new trial. I mean, generally, defense counsel's alleging procedural error, legal error during trial, and they're relitigating it. So the fact that Your Honor's ruled on this does not make it moot and does not make it impermissible for a motion for new trial.
All right, well...
But there is additional information that was not provided to Your Honor at the trial hearing. And before we get started, I'll be amending my motion, orally amending my motion to permit interviews of all 6 jurors and the 2 alternate jurors based on information I received 45 minutes before this hearing, Judge. I was told by a confidential source that for legal and ethical reasons, I cannot say on the record that a juror advised the source that Juror Castaneda was nodding off throughout the trial. This source is obviously unrelated to defense counsel pursuant to the law, as neither myself nor my agents can speak to...
You're ethically prohibited from...
Correct, Judge. And this confidential source reached out to me. I cannot ethically, on the record, say who it is. And if Your Honor orders more information, it would have to be in camera and under seal, but I will stake my license on what I was told, Judge, that a juror advised this source that Juror Castaneda was nodding off throughout the trial. And like I said, Judge, if you need more information, it would have to be in camera and under seal.
All right, proceed.
So, and it was not one of the alternates, but all right. I mean, moving on, Judge, I've given you, at this point, 7 affidavits at trial. I'd entered 6 affidavits into evidence. I have one additional one, which I supplemented. They're in evidence, but for purposes of this hearing, I'd move...
Mr. Williams, we'll see the last.
Yes, Judge. I'd move all 7 into evidence as defense composite 1A through G.
I think they're already in.
G's not, but just to make the appellate record easier.
G, who? Wait.
That's Mr. Williams, but just to keep them all together, I thought I would.
State any objection?
No, Judge.
All right, so it's A through what, Mr.
I
Rosenfeld?
believe it's defense composite 1A through G.
1A through G.
Is that right, Madam Clerk?
All right, they'll be in evidence for this hearing without objection, although, like I said, I think I accept all of those for the record during the course of trial, and I ruled on this before, all except for Mr. Williams' affidavit, which a copy was sent to me in advance of this hearing.
Yes, Your Honor. I'm just not sure if, based on the argument made in the petition, based on the protective order, whether an attached exhibit does constitute evidence. And that's one other story, but moving on, Your Honor. These affidavits reflect, as we previously argued, that Juror Castaneda was sleeping during critical testimony, and specifically, that would be the confidential informant Mohammed Shihade and our expert witness, Tim Williams. And it's our position that Mr. Shihade and Mr. Williams were the most 2 important witnesses in our case. I think that was clear from the second trial in regard to Mr. Shihade, and Tim Williams' importance for us can be reflected by the fact that we flew him in from California. And as Your Honor heard during his testimony, he was paid quite a bit of money. In the affidavits, 3 people actually saw alternates appearing to try to wake up Juror Castaneda during these critical points in the trial. And I want to go through some of these witnesses. Myself, who swore as an officer of the court, Natalie Vallejos, and that was Mr. Claypool's legal assistant, Tim Williams, who has 43 years of police and investigative experience, including the Los Angeles Police Department, who saw her sleeping during his testimony, And more importantly, Judge...
Observation, Mr. Rosenfeld, because I paid particular attention to her during Mr. Williams' testimony and have personally observed that she was not sleeping during that testimony. So that's an interesting, when I got that affidavit, I was very interested in that because I made personal observations, not only throughout the course of the trial, but in particular of her reactions to Williams' testimony. So that's an interesting affidavit that you filed. But go ahead.
We have other witnesses, Judge, who saw her sleeping during that testimony also. It's not just Mr. Williams.
Well, closing eyes or sleeping.
Well, I mean, I guess that's where...
They're not the same thing, Mr. Rosenfeld. I made these written findings on the record at the time of the trial. On a couple of occasions, she would go like this and she'd be tapping her hands and immediately reopen her eyes. I made those factual findings on the record. And in particular, I'm telling you, with regard to your expert witness, Mr. Williams, I paid particular attention to the jury and to her in connection with that testimony.
Well, I mean, Judge, that's... Frankly, and respectfully to this court, it is impossible for Your Honor to say you were looking at Ms. Castaneda the entirety of Mr. Williams' testimony. I have observed, Your Honor, throughout trial...
I didn't say I was. I said I paid particular attention to her during the course of Williams' testimony and the other jurors. Frankly, I was trying to gauge how they were receiving this testimony. You don't usually have experts of this type testify in these types of cases, and I was particularly interested in how the jurors were considering that testimony. So, no, did I stare at the jury the entire time? Certainly not. No one in the courtroom did. But I made particular observations during his testimony. That's what I'm telling you, Mr. Rosen.
No, and Judge, I'm respecting your observations, but I'm comparing those with 7 other people. And the last person I was going to mention is Kimberly Mayorga, Judge, my legal assistant, a courtroom clerk and judicial assistant for over 20 years, who was sat right there directly across from jurors and watched hundreds and hundreds of trials. I mean, these are people who, a woman who is highly respected and regarded in this courthouse. And if you're saying all these people are willing to put their professional reputations at stake in sworn affidavits to give their observations, I mean, then we're basically being called outright liars, Your Honor. And you have your personal observations, and I respect that. I'm not disputing what you saw and how you interpreted what you saw. But as I put in my motion, even the most astute jurors can be wrong. I mean, not for nothing, Judge, but you're not a sleep expert. I'm not a sleep expert. We saw a woman sleeping. We saw a woman, Your Honor said 4 times. What she has done on several occasions, she'll do is this. She'll close her eyes, but at this time, she's still moving her hands. She's awake, she immediately opens her eyes. 2, she is closed. She's done this a couple of times. She'll close her eyes and go like this, and she's going like this with her thumbs. 3, she might close her eyes occasionally, but she's not sleeping when she does that. And 4, she has occasionally closed her eyes. Now, I gave you one article, and there's tons of research on this, about hand movement, motor movement, while people are dozing off, while they're sleeping. You have sleepwalkers. You have jaw clenchers. And if she was moving her hands isn't indicative of the fact that she wasn't sleeping. And frankly, Judge, the case, I mean, Ms. Dippolito has a constitutional right to an attentive jury. An attentive juror. She doesn't have to be sound asleep drooling on herself in the jury box. That's not what the law's requiring, Judge. If she's dozing in and out, if she's moving her hands, I mean, that's certainly enough. And, you know, when you have, and I'm not disputing for a second what you observed and how you interpreted what you observed. In the same way, I'm not disputing what I observed when I was standing, obviously not in this courtroom, right here during Mr. Chiade's testimony, looking at her. You know, that was my interpretation of it. That was Ms. Mayorga's interpretation, sitting right there, staring at her. That was Mr. Williams' testimony, sitting right there, Tim Williams, not that Williams, staring at her. I mean, these are people who had all different angles, who had a different interpretation. So that begs the question, Judge, what if you were wrong? And we're balancing Ms. Dippolito's constitutional, state and federal constitutional due process rights against what was a minimal inconvenience to this court, questioning those 2 alternates. I mean, it would have taken 3 minutes. Nobody would have known why. I mean, it is of no prejudice to the state whatsoever to have questioned them. They agreed to those alternates. They didn't exercise their peremptory on those alternates. So there was no prejudice to the state, no inconvenience to this court. And this court has a legal and ethical obligation to ensure that Dalia Dippolito gets a fair and impartial trial by attentive jurors. And if there was a rational reason, then I simply can't think of one, why she was not questioned, whether it be a major inconvenience to the court or prejudice to either party. I would understand that. But this court, as a matter of law, I mean, every court, as a matter of law, has to err on the side of protecting a defendant's due process and constitutional rights. And I would move the article I presented, Your Honor, into evidence as Defense Exhibit 7, and this is all I could, pull up last minute, but on some hand movements and REM sleep, just to show that motor functions don't necessarily correlate with a person being...
I do, Judge. That article says nothing about what it's implying.
It speaks about REM sleep and psychological responses to dream motor performance and REM lucid dreams.
Judge, you can read the article. It has nothing to do with what he's saying.
It does, Judge. Does it refer to a sleeping juror in a jury box? No. The inference I'm drawing from this, Your Honor, is that it is possible for a person to show movements at point in sleep. Whether it be...
I don't think that's...
So you can take the article for what it was.
Proposition that people move when they sleep. I mean, if that's what this article is...
That's not what it says, Judge. It's about people that are lucid dreamers, which means they're partially awake and partially asleep. And they told them ahead of time, hey, we want you to make movements with your eyes and your hands by clenching your fist while you're sleeping, so we know why you're sleeping. He didn't bother to read the article. It has nothing to do with
I did, and how else do you test someone aside from doing clinical tests? So if Mr. Williams let me finish. And as I just stated, Judge, this is not at any way the situation that occurred, but I'm just indicating to this court that there are situations where people move when they sleep, or they move their hands.
Well, first of all, let's just get to the bottom of them. I'll overrule the state's objection. You want to put that in evidence, I'll allow you to put it in evidence as Defense 7. But as a general proposition, I will accept that people move when they sleep.
And I think, Your Honor, that even if she was drifting in and out, let's say she wasn't sound asleep during trial, let's say she wasn't attentive, being attentive at points, I mean, we necessarily have a bona fide dispute of fact, and the only way to resolve that is to question the jurors. Even at this point, nobody would be prejudiced. All that can come from this, I mean, worst case scenario, we find out the juror was sleeping, or worst case scenario for the state, I guess, and Ms. Dippolito's state and federal constitutional rights, she was deprived of them. They were eviscerated. Okay? Best case scenario for the state, I'm wrong, Your Honor's right, the state's right, and my 7 witnesses are wrong. But by no means is anybody inconvenienced by this. I just don't I can't wrap my brain around the fact that why everybody in this courtroom, I mean the state included, who are also officers of the court, would not want to ensure they're quasi-judicial officers, that Ms. Dippolito receives, this fair and impartial jury that, as officers of the court, we're required to uphold. Judge, I think in light of the information I provided, Your Honor, briefly at the beginning of my statement, which would demonstrate to a certainty via in-camera sealed hearing that Ms. Castaneda was nodding off throughout trial, it wouldn't be a bona fide dispute, it would be a fact. And like I said, I will stake my license on the information I was told that juror number 3A, juror Eileen Castaneda, was sleeping during trial. And if we want to, we can do nothing. We can just sit here and deny my motion, and we can all speculate, and we can all sit back and challenge whose perception of someone's body movement was correct. The 7 witnesses I have, including myself or Your Honor. But I mean, the fact that we have that many witnesses creates this dispute of fact that we need to resolve.
All right, let me hear from the state.
And just can I just respond to a few of their arguments in their motion, Judge?
If you want to do it now, you can.
I'll beat them to the punch. I know what they're going to say. It's right here. First of all, a lot of the allegations that were sleeping throughout trial were brought to my attention, not the ones I mentioned in my affidavit, by my witnesses. So they're saying I didn't approach it, I didn't bring it up every time. The two specific instances, once it was brought to my attention, I observed, I put in my affidavit, and that was during the critical testimony of the defense witnesses. That's point 4 the state raises. Point 6, the state talks about me moving to the side of the jurors and watching every move, which is incredibly incorrect. I stood in the corner, sitting in a chair where I could not see, and the purpose of which, as I asked Your Honor permission 1 or 2 times, was to watch what the state was playing. Mainly my concern if anything came up that wasn't redacted. But in both trials, I've sat in the same position and I've watched the video. I've probably done that in the 50-plus trials I've tried. Number 7, Judge, in regard to Your Honor, and I'm going to quote my motion, even the most attentive jurist or astute jurist can be wrong and can miss these things. I mean, I watch Your Honor. I know you take very detailed notes, and I know that because you've called me out before. And at times I've agreed with you and said, you know what, Judge, I think you were right on what was said. So Your Honor's not always looking at the jurors. You have several functions up there. I mean, as I put it, I don't wear a robe, so I don't know what it's like being up there, but I know you're looking at counsel, you're looking at the state, you're looking at the jurors, you're looking at the witness, you're taking notes. So it is just, it's very possible for Your Honor to miss things, even given the state's allegations here. And the state's saying that they have the second best seat in the courtroom. When I watch them throughout trial, they're sitting there taking notes, talking, doing what they're doing. And I guess, assuming what they're saying is true, we now have, and there's no testimony or affidavits from them, we now have 7 versus 3 in terms of people who have one interpretation versus people who have another interpretation. And to say she was the second most attentive juror is as far from the truth as you can get. I mean, you can say that, I mean, their position is that she was not sleeping, fine, but saying she was the second most attentive juror is just, I'm going to bite my tongue in using words here, Judge, but I think you know where I'm going with it. That is as far from the truth as possible. But I will rest on the fact, Judge, that we have a bona fide factual dispute. If Your Honor wants additional information, I believe we're entitled, or let me withdraw that statement. I would respectfully request an in-camera sealed hearing to give information that is privileged that I cannot give on the record that would settle this bona fide dispute of fact, Judge. Thank you.
All right, Mr. Williams.
Judge, have you seen the Foraker case?
I'm sorry, the what
Have you
case?
seen the Foraker case?
No, I saw that you filed the response. I just got your copy of the response. I haven't looked at any of the cases. Do you have a copy from Mr. Rosenthal?
It was cited in there.
I don't have a copy, Judge.
I'll give you my copy in a minute if you want. Yeah, print another one out for Mr. Rosenthal. Okay, I've read the case. I mean, there's only one small portion of the case that even relates to the issue.
Paragraph. Judge, I don't know if there's anything you wanted to ask me. I'm going to rely on a reply. Foraker was right on point. This is a non-issue. The court should end it right here.
Do you want a chance to look at the case, Mr. Rosenberg? I mean, the only thing that's relevant about the case, I mean, the third footnote, there's a brief discussion of the court's handling of an allegation of a juror sleeping. I mean, it doesn't.
I mean, I see point 3, and I assume that.
I mean, it does. I don't
Is
know.
the last paragraph the only paragraph that's relevant?
Yes.
Well, there's nothing in this case that indicates evidence put on, so the level of evidence we've put on in regard to the sleeping juror. They noted the court's observation. I mean, if counsel makes an observation, the court makes another observation, I mean, that's one thing. They referred to Foraker's daughter, that's one person. She wasn't sure if she was sleeping or merely had her eyes closed. Let me I'm sitting down, I apologize.
That's all right.
Rude to the court. In our case, we have 7, not 1 people who indicate that she was sleeping, and 3 of which indicate that the alternate sitting directly next to her is, the allegations have been told, and they indicated that she was woke up, that's what they were referring to, had to wake her up, which goes, I mean, that's a whole nother level than Foraker. I mean, I think Foraker is, it doesn't rise to the level of what happened, the egregiousness of what happened here, Judge, in terms of her behavior during trial.
Okay, here's the thing. This isn't a situation where I'm sitting as a fact finder, listening to evidence presented to make factual findings. So the fact that you filed 7 affidavits from persons associated with the defense team indicating she was sleeping, or the fact that I even got counter affidavits, which I didn't from the state, but even if the state had given me testimony, this is not a circumstance where I weigh evidence and make a ruling. This is a circumstance that the court is called upon to make personal observations and to make a finding based on those personal observations. It's not a weighing of the evidence standard. It's a personal observation standard. Had I not made a personal observation, it would require the presentation of evidence. That's not the case here. I made a personal observation and made those statements on the record at the time. Based on my personal observation, I found that Ms. Castaneda was not sleeping, that she was paying attention during the course of the trial, and therefore I denied your request to remove her as a juror. I denied your request for further juror interviews at the time. And I'm going to deny your motion again. It's based on my personal observations. The fact, again, it's not a fact finding, it's my personal observations I placed on the record at the time. In terms of the juror interviews, candidly, juror interviews are appropriate for matters which occur outside of the presence of the court. In other words, premature negotiations, a juror doing research or doing experiments like happened in the first John Goodman trial. Those are matters which occur outside of the presence of the court, which require, if sufficient allegations exist, a juror interview. This is a matter which occurred or didn't occur in open court in a place where the court can make personal observations. And so a juror interview is not even required or necessary in this type of a case. So the motion for a juror interview is denied on that grounds. It's also denied on the grounds that, again, I made my own personal observations with respect to this juror, placed those observations on the record. I found that she was not sleeping. I found that she was paying sufficient attention to the proceedings, and I'm sticking by those observations. So the motion for juror interviews is denied. The motion for a new trial on that basis is also denied. I do have some homework for you guys, though. Sentencing is next Friday, I believe.
Yes.
Is that right? By Wednesday, I want the parties to agree on the jail credit, how much credit Ms. Dippolito would be due. So there's no misunderstanding about jail credit. Let me define jail credit. Jail credit means how much time did Ms. Dippolito spend at Gun Club. That's jail credit.
Correct. And I will agree with the state on that, and I do recognize the case law on house arrest and this court having no discretion to, except for very limited situations, to give Ms. Dippolito credit for house arrest. I know it was litigated in Goodman.
Licata was the first Fourth DCA case that found that, citing to a case called Brewer out of the Fifth.
Correct.
But, yeah, you can't even do it if you want to.
You can if you want to, but
Not
I know
according
there
to
are
the
some
Fifth.
interesting arguments in Goodman that I have not read the brief. I know it was filed in a motion to correct sentence, which I have reviewed.
The state filed a motion to correct?
No. The
Defense?
Ms. Grant filed it. Sherry Grant had filed a motion to correct sentence. This was pre-appeal.
I don't remember what
I mean,
that was Colbath's case, it wasn't mine. So I
It was
don't know what
denied,
it was.
based on the case law Your Honor had
Licata?
stated. However, there might be some creative arguments I may present, but I will agree with the state as to the amount of actual...
You can make whatever creative arguments you want. I don't have any problem with that. If you look at the 5th DCA case of Brewer, it might give you the creative argument you're talking about, but it still holds very clearly that you cannot give credit for in-house arrest, which appears as if it might have happened in the first trial.
I'm sorry, was that?
Did that happen in the first
There
trial?
was, the state, Ms. Parker did not object to the credit being given, but I don't know of any case that says that the court is then bound, or the state is bound by that same agreement.
No, I'm not saying you are. I can't enter an illegal sentence anyway, but my point simply was, looking back on the other sentencing order, it looked as if that must have been done the first time, because the credit was like 600 and change days,
I read the...
which could not have been. I don't think Ms. Dippolito wasn't in jail for that period of
No,
time.
she was not. It was house arrest credit.
Okay, so it got me curious. It looked like it was.
Unless, I mean, I don't know if there was a...
There was not a finding that she was in custody. It was by a lack of objection by the state.
I don't know if there was a finding to the contrary either, so...
Doesn't really matter. I mean, at this point, I was just curious about it. It looked to me as if Judge Colbath had given credit, which under Licata would be illegal, but I don't know. It's not important. If there's no objection, typically a trial court, if the state's not objecting to it, then the trial court would probably go ahead and grant it. And I'm not even sure whether anyone brought Licata to the court's attention at the time, although it was decided at that time, so it was the law of the fourth. So you know what I'm talking about, Mr. Roosevelt, just what you want to do is get with the state and agree, because this goes way back. I mean, it goes back, Ms. Dippolito would have spent at least some time in jail after the arrest before posting bond.
Post-conviction.
Right, and then she would have been remanded after the first trial. There would have been time in gun club before being released on appellate bond. And then obviously I remanded after jury verdict in this case, and so we'd have to take into consideration. I just want to make sure, too often I come to a sentencing, I get ready to pass sentence, and then the attorneys haven't given me the credit, and you got to stop the whole thing to figure out what the credit is. That has to be pronounced at the time of sentencing, so it shouldn't be that well, I shouldn't say that. The reason I'm giving you advance warning is it may be a little more difficult than normal because you have to go back 8 years. But you need guys figure that out and give that to me by Wednesday. If you want to file any type of sentencing memorandum, I'd like to get a deadline for getting that in. Are you planning to do that? Is the state planning to?
Yeah, Judge, I'm in the process of writing that. I would say Wednesday's fine.
Mr. Rosenfeld, can you get yours? Are you going to? I would assume you're going to file some kind of
I
sentencing
am,
memorandum.
Judge. We, Your Honor did receive my waiver of PSI, and we do have I did. Mitigation specialist, so I'm doing my own mitigation. Generally I review the state sentencing memo before I write my own, so I can get some insight into what they're asking for, but I know we're on a little bit of short notice here.
Yeah, I mean, I don't think there needs to be a reply to their...
No, that's fine, Judge.
Go file your independent
Wednesday's
memorandum.
fine. My only concern is that I am on 2-hour call on a 15-year midman trafficking case in front of Judge Burton on Monday, which I doubt will go. I know we have some...
think you're going. I have a special set, so.
Okay. If you could just maybe let him know that we have some deadlines in this case.
Well, but his trial will take precedent. I'll have to extend my deadline.
It's not a speedy case.
Yeah, I mean, if you go, and let's just tentatively set the deadline for both sides at Wednesday. If there's a problem, obviously I'll listen to what the problem is.
And one other issue, or not issue, question, I don't know how Your Honor wants to proceed on this, and I have my preference, but obviously we'll be moving for an appellate bond.
I'll tell you what the procedure
Some
is.
that is here the same day, some here at other days.
Now, here's what you have to do, just so you understand. First of all, as a prerequisite to filing the motion, I have to sentence. So you need to file it. I'm not going to hear it the same day. I anticipated, obviously, you'd be filing one. You need to file the motion after sentencing. You do need to identify assignments of error.
Correct.
That doesn't mean you have to brief them fully. It's not an appellate brief.
Sure. No,
You have to identify, because your threshold to get to the youngins' evaluation, to get to that threshold, you have to show good faith appeal. So you have to do the assignments of error. So you can file as quickly as you like after sentencing, but I will not be considering that at sentencing. I will consider it after sentencing. You can get your motion ready to file, and I'll hear it as quickly thereafter as I can.
And I believe Your Honor has discretion to, and I don't know what your sentence is going to be, if it's going to be...
Well, that's part of the problem.
No, I'm saying if it's going to be DOC, not DOC, based on downward departure, who knows? But Your Honor can't keep her at Palm Beach County Jail until the appellate bond is heard.
Well, that's not a problem at all. That's
Correct.
absolutely. Yes, that's not a problem. That's just a separate order saying we have a pending motion to set appellate bond. Do not transport to DOC pending outcome and ruling on that motion. That's not a problem.
It should, I assume, most of the, at least evidence for the appellate bond will be heard at the sentencing hearing. So it'll just be legal argument.
Yeah, you can. I'm assuming when you're talking, I won't go through too much detail now. When you're talking about the youngins' factors, you're talking about ties to the community. You're talking about prior record. You're talking about severity of sentence, and you're talking about any other factors. The fourth is any other factors that the court wishes to consider with respect to temptation for flight. Those are the four youngins' factors. So if you want to present whatever evidence, you can rely on whatever evidence you want that's placed before me at the sentencing hearing. You don't have to have a second evidentiary hearing on that, if that's what you're saying.
No, I was just telling Your Honor that I think
I'm assuming a lot of that would come out at the time.
It'll just likely be legal argument at the motion for appellate bond in light of most of the evidence being heard.
Correct, because I'm assuming all of that is going to be presented, or you wish to present that in terms of sentencing in any event. So a lot of that would come out as part, ties to the community, that kind of thing, family, all that stuff, prior record, all of that, I assume would come out during the sentencing anyway. So you don't have to have a second.
Notice in advance I will be out of the country August 10th, so the appellate bond hearing has to be heard before then.
Or after, whenever. It has to be heard. It has to be heard when I have availability. I've got something to correct on the record for the clerk, I believe. Let me make sure I've got this right. Defense Exhibit 1, I've got a note, should be 1A through H. It was incorrectly stated as A through G. I thought she said A through H.
I'm going to give it a duplicate. Let me check. 1, 2. Oh, no. This is Exhibit 2, the last one, I'm sorry.
Oh, I think we called, you know what, I think on the record, did I call it 7?
The affidavits were A through G.
But the article should be 2.
2, correct.
All right, I think that's where the problem is. Okay, so get to me by Wednesday, agreement on jail credit. Get to me, unless you're in trial, Mr. Rosenfeld, your sentencing memorandum, so I have at least some advance opportunity, particularly since you've waived PSI.
Yes, yes.
So I have nothing in advance to look at. Okay. All right, we're in recess.
Court's in recess.